We are fortunate to have with us this afternoon two folks from the Office of Mental Health, and they're going to talk to us about a relatively new policy on use of force. Thank you. We have us here with us today, Isaac Rodriguez, and some of you may recognize this other guy, Bryce Therrien. Today is Bryce's birthday.
Oh.
I understand he's turning 29 today. I'll turn it over to them.
Hey, good afternoon, everybody. Thank you. My name is Bryce Therrien, if you haven't already met me. I worked at the Justice Center up until July of 2022 as a supervising attorney. I was mostly center of the state. Oh, I just saw somebody take a tumble in the back. Are you okay? All right. Anyway, I am. Oh, even better.
Just that thing's really sensitive.
Does this work too? Perfect. I am now Assistant Director of Employee Relations at the Office of Mental Health, doing kind of a little bit of everything, health and safety, and still a lot of employee discipline, guiding investigations, guiding policy. One of the policies that we're going to be talking about today, and Isaac is going to be doing a lot of that legwork because he's kind of an expert in it, is the use of force policy for our safety and security officers.
Hi, good afternoon. My name is Isaac Rodriguez. I work for the Office of Mental Health, specifically out of Central Office. My job is to oversee all the training that our about 620-ish peace officers receive across New York. Every psychiatric center, there's about 23 of them, all have a public safety department, and they all have peace officers employed. So I oversee the 2 academies every year, all the instructor courses, and then I oversee all their supervision for all their in-service that they have to do every year. And I teach the use of force module at the academy, so that's why I'm in front of you this afternoon.
So click through. All right. Just a quick agenda setting, since that typically makes our trainings go a little bit better and less freeform, is first off, what is use of force? I think a lot of people in this room are going to be familiar with our TRUST, or it used to be called PMCS training, which guides a lot of our interventions with OMH patients. People are usually less familiar with use of force since it really deals with a smaller percentage of our staff population, specifically with our safety and security officers. So we're going to be talking about that. We're going to be talking about when our safety and security officers are allowed to use the use of force, so the when is it applicable. We're going to be talking about how it's different from PMCS or TRUST or the YES. We also have YES for our children facilities. We're going to be talking about the information impact for investigations and litigation. So when you're investigating a safety and security officer for potential abuse and neglect, what should you be looking at? What actual policy? So you're not just calling up the trust trainers and asking them, is this compliant with the trust? You're asking also, does this fall under the use of force policy? And then with litigation, what should we be doing with your substantiations? What should we be doing with employee discipline? And at the end, I'm going to give you some contacts for people you can reach out to in each specific instance. A lot of times, you reach out a couple times, we talk you through it. It's a lot easier than in a 45-minute conversation we're going to have today. We're going to stay very 30,000 foot up. Just give you some core concepts, get you more familiar with it, but we're not really going to get into the nitty-gritty just because we don't have the time. So we're going to give you some contacts that you can reach out if you have an investigation or you have an administrative appeal hearing or you have an employee discipline hearing. You can reach out and we can talk you through it. This one I'm going to turn over to Isaac.
So just so we are on the same page, safety officers are uniformed peace officers that work at the psych centers. I'm a safety officer. The training that they receive is mostly determined by the Division of Criminal Justice Services, and it's identical in a lot of ways to all the law enforcement training that a police officer would receive. So when you're looking at what they might be doing, understand that it's not going to be in PMCS or TRUST. They are expected to use those interventions when appropriate, but it's not going to always be the case. They are authorized to use reasonable and legitimate force. So That reasonableness standard is going to come from the Fourth Amendment, and that's going to be how we're going to determine what they did is generally okay or not in terms of the legal standard. And while it is an objective standard, it's going to have some subjective factors. So the kind of example I like to give is an officer uses force, and when they write the report, it should resemble something like this. I observed this, I observed this, I observed this, which led me to believe something. So for example, I observed the subject make a closed fist. I observed the subject take a fighting stance. I observed the subject scan the area, which led me to believe that my officer's safety might be in jeopardy. Some of the times that officers are going to use force is generally going to be to protect themselves or others from force being used on them or on a third person, or to prevent escape or to maintain custody. I think that's about it for that slide.
All right, this is a few references. As Isaac just mentioned, the use of force, our safety and security officers are uniformed peace officers. So they are different than most of OMH employees. Most of our OMH employees, we have direct care staff, we have social workers, we have nurses, we have a whole range of employees. All of those employees are trained in what is now referred to as trust training. Don't ask me to tell you what the acronym stands for, but essentially it's the de-escalation and restraint training that we provide to all of our employees that interact with staff. Our safety officers are on this other track. So when I'm giving these references, these are going to look a lot similar to what, say, a police officer would be, what they would be following when they were restraining or doing anything physical with a suspect. So for this one, we've got down right at the bottom, as Isaac just mentioned, Bill of Rights, Fourth Amendment. We also have internal policies. A lot of people, because we just updated what's called our 3000 policy, aren't as familiar with this as they are with the trust training. But we have just updated in the last year or so what's called our 3000 policy, and there's two specific sections of that 3000 policy, 3023 and 3024, that really details what a safety officer is allowed to do and what the expectations for a safety officer are when they are interacting with a patient in OMH care, and when they are restraining a patient in OMH care, or when they see a situation that could be dangerous inside of an OMH facility. Those policies are extremely explicit. Most of you, if you've seen the trust training is really, really long. There's a lot of stuff in there. There's a lot of very specific restraint techniques laid out in that trust training. These policy manual sections, I think between the two of them, are about 14 or 15 pages long. It's much more explicit, but also fairly wide-ranging as to what a safety officer is allowed to do. So if you're looking at a safety officer case, I would recommend becoming familiar with those. I would also look at, these are based around Mental Hygiene Law 7.25. A lot of people, when they think about mental health care, they think about health care in general. The only thing you ever really think about is HIPAA, because everybody's heard of HIPAA before. But HIPAA is really not applicable to most situations at a mental health facility. What's actually applicable is the mental hygiene law. New York has a very explicit mental hygiene law that you should become familiar with if you haven't done it and you deal with OMH facilities. With this one, Article 7.25 is what deals with safety. If you're dealing with one of these cases, I would recommend, again, looking it up and giving it a quick read. Then I referenced a couple United States Supreme Court cases, which really unpack, as with any policy or any standard, there's going to be language, there's going to be situations that are a little bit more nebulous. These are two leading Supreme Court cases that unpack what the use of force standard is, and what safety officers and what peace officers are allowed to do.
And I just wanted to mention, if you go just onto Google and you just type in OMH policy, you can find the 3000 series. It's online and publicly available. And generally speaking, that policy, it's in line with the law, The few places where it is more restrictive than the law are going to be generally regarding chokeholds and pain compliance. Otherwise, it's generally in line with the law. So, use of force, it's not a therapeutic intervention, and the reason why is that while our direct care staff are typically going to be working on the units, your safety officers, if you read 7.25, will say that they're supposed to fully protect the grounds as well. So if there's trespassers, if there's people on the property damaging the property, selling drugs, damaging cars, stuff like that, your safety officers are going to be responding to that too, and that's why their level of training is going to be similar to a police officer. Use of force, obviously, there's a lot of case law involved, so you can improvise. It's not going to be as rigid all the time. And because of their peace officer status, your safety officers they don't have a duty to retreat. That doesn't mean that they can't, or if it's prudent to do so, that they won't, but they'll avoid trying to create what's called like officer-created jeopardy. If there is a client in a room who is agitated, but there's no other dangers in that room, it doesn't make sense for that safety officer to necessarily go in there. So if they were to enter that, they would be probably creating that jeopardy. But typically speaking, the officers don't have a legal duty to retreat. And then there's the reasonable officer standard, which comes from case law. And it's important to note that they call it reasonable for a reason. It's not the minimal standard, it's not the necessary standard, but it's a reasonable standard. And that's because they're not expected to have 20/20 hindsight. Just like you wouldn't expect a firefighter to not go a drop over putting out a fire, officers and their force simply just need to be reasonable. Does it make sense? And that's why that report format is them explaining what they observed and then coming to their own conclusion in an effort to convince the reader, this is why I made that decision.
And I'm going to highlight that first bullet point on that slide where we specifically say this is not a therapeutic intervention. So I can't count the number of times that we have had cases where you'll have a whole host of nurses or social workers or what have you say the safety officer did X, Y, and Z. That's not compliant with what we believe the training says. We're supposed to be doing therapeutic interventions. That's not the standard for our safety officers. Our safety officers are not there to provide mental health treatment to our patients. They are there to ensure safety. So the standard that all of other staff are held to under the trust or the yes or whatever you look at, where everything they do, including when they are physically restraining a patient, is supposed to ultimately be therapeutic for that patient, that's not what we're looking at for safety officers. And so it's a real hard line there.
And I get a lot of questions a lot of times from the officers coming through the academy or in service, and they'll usually ask, well, under what conditions do I switch from one to another? And I explained it to them that usually trust, the idea behind trust is that there's certain conditions, that there's direct care staff, they're within a safe environment, and that you have therapeutic interventions available because there are direct care staff who are trained in that. A lot of times when safety is starting to get involved, it's because that's broken down or those resources are not available. So when a patient leaves the facility, they escape, or they're otherwise in a situation where they're not on their ward, in that case, the nurse that maybe knows that patient best or knows that patient's treatment plan is not available. The officer doesn't have the same resources that they otherwise would. So this next slide, when it's applicable. So when safety is specifically asked to intervene, every facility is going to be a little different. I originally worked at Rochester, and at that facility, when the request or the notification of a psychiatric emergency was announced, all available staff would respond, to include safety. And at that facility, the officers will typically respond to the unit. They'll get close, but they'll remain out of sight. They'll usually stay in the nursing station around the corner, outside of view, and they only get involved when the trust techniques are starting to break down or there's some sort of weapon involved, deadly physical force is present. Not all facilities are like that, though. For example, at some facilities, the officers will come to the unit, but not actually enter the unit, and they'll remain outside the unit until they're specifically summoned into the unit. And at some facilities, the officers won't respond at all unless a second notification is broadcast, at which point then they'll respond. So every facility is a little different, but all officers are trained that you're not the first line of intervention unless trust has broken down, there's a weapon involved, serious physical injury, or deadly physical force is present. If a officer can articulate why he thinks that it was unable to be de-escalated, maybe there's a medical issue, they can also intervene as well. And the standard I keep mentioning, that deadly physical force, that serious physical injury, that's going to be something that causes some sort of protracted disfigurement or is likely to cause a person to go to the hospital. Things that are permanent, like broken bones, losing an eye, something like falling down a staircase. That is at that higher level of force as opposed to pushing, shoving, stuff like that.
Yeah, so I want to be very clear because it probably sounds like we're saying you really should never substantiate a SSO, right? But that's not actually what we're saying here. Our SSOs are also trust trained, so they have the ability to do de-escalation, but we have very clear expectations of our SSOs. They should really be out of sight until specifically called upon by other staff. So if you say, have an instance where an SSO sees an ongoing de-escalation and that SSO jumps right in and starts physically restraining a patient, that's entirely inappropriate. If an SSO is making even their presence felt while a de-escalation is ongoing, a lot of people in OMH care have very negative opinions of uniformed officers, have had a lot of negative interactions with uniformed officers, and that can often completely derail a de-escalation. Our SSOs, if it's possible, should be entirely out of sight, and they know that. They are also, as I just mentioned, trust trained. So if they happen to find themselves in a situation where they are presented with an escalated patient, and it's not, at least to the view, as an objective viewer would view the situation, de-escalation would then be impossible. They're still supposed to try to de-escalate that patient. They're not supposed to de-escalate them in a therapeutic way, but they're supposed to use every therapeutic intervention that they've been trained on in order to try to de-escalate that patient, to avoid having to jump into a physical intervention. If other staff have already engaged that patient and have the situation under control, even if it's an ongoing restraint, uniformed officers should not get involved. If they get involved and they escalate that patient or they engage in any kind of physicality with that patient in a situation where it's not called for, still inappropriate. You can still go ahead and investigate them, potentially even substantiate them. I'll be talking to you at the end of it, and we'll probably be looking to discipline that person, all right? So there are clear expectations on those safety officers that really we don't want them interacting with the patient unless they are absolutely needed to interact with that patient. So even if they get pissed and want to jump in on behalf of their fellow coworkers or what have you, inappropriate, not supposed to happen. On the flip side, you've also, when I worked at the Justice Center, I saw a bunch of cases like this as well, where we had our direct care staff or we had our clinical staff refuse or tacitly refuse to intervene with a patient, where they see an escalated patient and they walk the other way. And they're like, somebody else will deal with it. The safety officer will deal with it maybe. In those instances, I'm likely, especially on the disciplined end of things, going to be telling you that's a huge mitigating factor for whatever that safety officer ended up doing if they ended up being the first person to make contact with that patient. Because really that shouldn't be happening. The first person to make contact with an escalated patient should always be direct care or clinical. Safety officers, I know they're out there. There are a lot of staff that think, well, I've got a safety officer over there, they can take care of it. No. And I'm going to use that as a huge mitigating factor on the safety officer's behalf if that ends up happening.
And the officers generally know that. A lot of times, and we were actually talking about it earlier, is that staff will say something like, well, our staffing is so low. We don't have enough direct care staff available. It might be the midnight shift, and there's just too many patients that need one-to-one care at that moment, and then safety will get involved, and we're warning them you should not be doing that unless there is some sort of mitigating circumstance, a higher level of force. The only other times you'll often see officers usually being that first contact is, like I said, when it's outside the building. At that point, For example, at Rochester, direct care staff don't leave the building. At that point, it's a law enforcement matter. Safety is going to intervene at that point.
Yeah, it looks like I kind of jumped the gun on this slide. So basically what I just said.
So this next slide here, it gives a list of what we call Graham factors. Graham factors are going to be things that are going to make force more or less justified. And those can be things like the severity of the crime at issue, the number of suspects, the physical condition of the officer or suspects, stuff like that. Safety officers, generally speaking, have some of these things in their favor, but not always. For example, unlike maybe some other agencies, our radios only talk to other safety officers. Safety officers as peace officers receive less training than police officers, significantly so, in terms of like maybe months of training difference. There is no physical fitness standard for safety officers, so there's nothing that prevents them from becoming out of shape and not being able to use force as reasonably. They may have low staffing. There's a lot of things that could affect that. But at the same time, because they're working at these facilities and they're interacting with patients, they know these patients better. They still interact with them, and they can develop rapport. And a lot of times, safety doesn't even have to get physically involved. There's a rapport there that allows something to be de-escalated. And while there is a list here, the Supreme Court has numerous times said this list is not exhaustive. If you can articulate it and it makes sense, then generally it will be accepted. So while use of force is the legal side, defensive tactics is going to be the physical techniques that officers are going to receive. The minimum standard in New York for all law enforcement officers is about 40 hours. We give them about 55. Plus, they receive about 7 hours annually every year to be compliant with state law. These techniques are not as rigid as trust. While we do offer them specific techniques, and there's quite a lot of them, because techniques are subject to failure and because altercations can be so dynamic and fast-paced, they have principles underlying those. So, for example, if an officer is taught a specific way to deflect an incoming punch, because fights are so dynamic, that may not work. Maybe the person's significantly larger, maybe the officer's tired from overtime, we don't know. But something could go wrong. So in that case, we give officers a set of principles like angles, leverage, distance, timing, space, stuff like that, so that when something goes wrong, they can still use force within a reasonable way. Because of that, when I'm reviewing uses of force, or I'm watching my trainees in the academy trying to evaluate, hey, is what you did okay or not, as long as it doesn't violate the principles or the law, generally speaking, it's not illegal. It's not violating a technique. Because, as you might imagine, if anyone has ever watched a boxing match or a mixed martial art match, it's hectic. There's a lot of dynamic stuff going on in there, and as you might imagine, something so static and rigid is not going to always hold up. And while safety officers they're not armed with firearms, the only weapons that they will carry, if at all, will be right now an expandable baton. Generally speaking, though, that baton is not designed for use with patients. Should a use of force rise to such a level where it becomes deadly physical force, that's a different story. But generally speaking, deadly physical force is reserved for situations where deadly physical force is being used on them or a third person. An example of that would be a knife or a broken shard of plexiglass that's jagged or a sharpened toothbrush or something along those lines. In that case, then baton would be reasonable. Generally speaking, the way a baton is supposed to be used is supposed to be for just regular force. It's not supposed to be deadly physical force. But because an officer doesn't have a lot of other options, it's not explicitly excluded by the policy. But that should be an exceptionally rare circumstance. And then it does mention there, and I mentioned it earlier, chokeholds are considered deadly physical force. When we look at how we define a chokehold, the intent is to create or render unconsciousness, right? So something like checking a pulse, while maybe the technical definition of a chokehold, it doesn't render unconscious, it's not the intent.
All right. So what does this mean for your investigations? What does it mean for your litigation? The first, if we haven't communicated it clearly enough, is the title and role of the subject is absolutely critical. If you're looking at a situation and you see a uniformed officer, that should really tick a box in your mind that we're not talking about the same standard usually that we would be looking at with other investigations. Our safety officers are uniformed. So if you're looking at a video and you see a uniform, you should be thinking use of force. Very, very rare exceptions that I talked about earlier, which is that if they show up first and there's still a potential to de-escalate, that is still expected of them. But 99.9% of the time, if you see a uniform, we're going to be talking about use of force instead. The people to reach out to are also very different. So a lot of people in this room, recognize a lot of people, have been calling Lily's team, have been calling Johnny Barnes, have been calling the other trust trainers to talk about, can you analyze this restraint? Can you look at this video and tell me what you think? For uniformed officers, those are not the correct people to call. Isaac's team is the correct people to call. Denise Hotailing, who heads up our training for peace officers, she's the correct person to call. The last slide is going to have her contact information. If you need to talk to somebody about the litigation side of use of force, call me. I'll direct you to where you're actually supposed to go. So you're not talking to somebody who's not qualified to answer your question, because that would be a waste of everybody's time. As I said, the trust standard might be applicable, but really only up to a point. Safety officers also, if we go to the next slide.
I go too far? No.
The paperwork, yep.
Yeah.
Also have very specific types of paperwork that they fill out. So if this is not already in your investigative file at the end of an investigation involving a safety officer, this should be in it. You can ask for it. It should be there. If it's not there, you should be comfortable asking, why not? Where is it? Those include the post-incident forms. Anytime use of force is applied, safety officer has got to fill out that post-incident report. 250 safety reports. There's specifically every safety officer in every one of our facilities is going to know what a 250 report is. So if you say 250 report, they're going to know what it is. They should know where to find it. Standard incident reports. Any restraint in one of our facilities, an incident report's got to be filled out. So just like you would do with a trust or a PMCS or a YES investigation, those are our normal restraints. Those are yeses for our kids. Our normal incident reports are also still going to exist for these as well. And workplace violence forms. So if this incident rose to the level of a restraint because the patient was acting violent, right now the Department of Labor is telling us workplace violence forms need to be filled out for almost every one of these restraints as well. Whether that's going to happen every single time, I can't promise you that. I have some disagreements with the Department of Labor about whether that is the actual standard that our facilities need to be held to, given the number of restraints that we engage in. But for a lot of our restraints, there's also going to be a workplace violence form, which is also going to have more information in it. So when you're doing these investigations, when you're doing your 72-hour reviews, when you're doing your full investigations, when you're reviewing these cases for your administrative appeals or for employee discipline, ask for these. They're out there.
I just want to point out real quick that those 250 forms, as mentioned, are standard across OMH. They may be some facilities that are still holding out and using the handwritten ones, but most of the time it should be electronic. And if there's follow-up to that specific 250, there should be addendums added in there. And as mentioned, there is a new use of force report form in the 3000 series, and they should be also completing that form as well.
So this one, also the training is different. Isaac can talk to you really briefly about how much time do we have left?
Yeah, we're doing pretty good.
Good?
Yeah. So right now, I actually left from Utica to be here. There's a group of about 26 peace officers at the academy right now. And right about now, they are probably on the mat very sweaty. They're actively training. The training is going to be a lot like you would imagine, like a high school wrestling class. It's a lot of on the mat, actively moving. It's very athletically demanding. It's very physically intensive. It's exactly what you would think about if you just Google onto YouTube and you see, defensive tactics. That is what you're going to see. It's no different. The curriculum's identical across all law enforcement agencies in New York. It's very grappling based. It's not that officers are not allowed to use strikes, but strikes don't really impart control on a situation. In fact, if anything, it just escalates the situation. It's a very grabby, holdy, kind of control, restraint-based system. It is called defensive tactics because it's defensive in nature. It's just the system of control that officers use to gain compliance or overcome resistance into arrest. Yep, and there is, for their in-service, they do have a video. It's no longer publicly available, unfortunately, but I have a copy of it if anyone wants to see it. It's about an hour long, and it's just talking about use of force, but not defensive tactics. Officers are required by law to receive at least a few hours of training every year for their actual defensive tactics, which involve getting on a mat and actually practicing the moves under at least a little bit of resistance.
Yeah, and that training is generalized for peace officers in general. It's not specific to our safety officers. However, it's, as Isaac just said, hour to an hour and a half long. Periodically, they have flash cuts and they have exciting music to try to get you awake as you watch it. It's actually not, it's pretty informative as to where the people who are training these types of tactics are coming from, which really informs because the use of force is this reasonable officer standard. It really is, if you are an officer, what would you find reasonable? Watching this video to see how peace officers think about these situations is relevant when determining whether somebody did anything wrong. Because it's not you or I sitting here thinking it's reasonable or not. It's a person with this training, with this background, what do they think is reasonable? So this is going to be a confusing phrase. It's from the last slide. The analysis, it's more subjective because there's so many factors that you could weigh in as to whether this officer did anything wrong in a situation. There's not typically, like there is with trust, a ton of slides that they get trained on that these are the 27 different restraint techniques that you're specifically allowed to engage in. It's really a lot more nebulous than that. I think Isaac put it well when he was describing it more similar to a boxing match, like you do in that situation kind of what you have to do to get the person under control, with the bar on escalating that person or engaging in something that would be considered deadly physical force, which is a whole different standard.
And just to kind of highlight how much gray area there is in this area of law. I'm not a lawyer, so I'm going to try my best to recount this, but I had a lawyer explain this to me at a use of force training. And the story he tells, and it's a real course case, I can give you the information if you'd like it. There was some NYPD officers on Broad Street around 57th Avenue, I believe it was, and it's about 2 in the morning, and they observed 2 men fleeing from a certain corner. They were looking over their shoulders as they were running, and they ended up running in front of this unit of police officers. The police officers recognized them, and they had previously been arrested for things like stealing watches from people, usually tourists at a certain area of the nightlife area of New York City. And earlier that same night, those officers had told those specific 2, hey, we know that you do this, you need to remove yourself from this area. Obviously they didn't. They seized these 2 people, they stopped them, they detained them briefly. And one of the officers in this group went up the street and found a gentleman saying that he had had his watch stolen. So then they brought them to the suspects, and they were identified as, yes, these 2 stole my watch. The lineup was held up in court. It went to court. The judge at that level, the Supreme Court of New York, said conviction, right? So it gets appealed. It goes up 1 more level. At the appellate division, there's 5 judges. And 2 of them thought that what the officers did was reasonable. 3 of them said no. It got appealed again. It went to the Court of Appeals, where there's 7 judges, and the court said that we don't have the jurisdiction for some legal stuff that I don't quite understand. They didn't have the jurisdiction to see that case. But one of those judges dissented, and they said, what the officers did was reasonable. It shouldn't have gotten to this level anyways. So if you're paying attention, we had the Supreme Court judge, and then 2 more, and then 1 more all saying, hey, that's reasonable. We had 3 say, no, it wasn't reasonable. So even though I know it doesn't really matter because it's really only what the appellate decision, the appellate level says matters, if it took like 13 judges over the course of 5 years, because these repeals, to still not be able to agree upon what was reasonable or not, how do you expect safety officers to make split-second decisions with a lot less legal training and come out making the right decision? The only real answer there is that you just have to do your best, document it as well as you can, and try to control yourself in the moment and not become upset. Because even in that scenario, that was just a simple seizure, just making an arrest. There was no force involved. So if you were to take that same situation and maybe they become assaultive, and now the officer has to, while actively defending himself, also make the decision to, am I applying force reasonably in that moment? It's quite the standard for really only receiving about 6 weeks of training. So I just ask that when you read the reports, please remember that officers, they don't get as much training as the judges and lawyers that are usually overseeing their cases.
All right. And I put some contacts up there. Really, if you take nothing else away from the 45 minutes that we've been talking, is this, that don't call Lily, Johnny, Chuck Schumer. The rest of them, don't call the trust training team if you've got a use of force case. Call Denise, call Isaac. If you want to talk through a investigation or you want to talk through a discipline case for a use of force case, my contact information is up there as well. I can tell you my office, we weigh in all of those mitigating factors when we talk about discipline for our safety officers. It is very clear that that is one of the top things that we talk about when we determine whether somebody should be penalized at all and the gravity of the penalty that we are levying against them in employee discipline. So that's really again, if you don't remember anything else, just remember that and call those people instead. I think we have like 5 minutes or so if we have questions.
Oh.
Julie.
Bryce, how is use of force a new module, or is it always been around? 'Cause I don't know that I remember it.
It's not new.
Okay.
We just updated our 3000 policy, so it is now, what's the best way of describing it? We have very clear language that details our use of force policy, whereas in the past, we were more reliant on general peace officer case law, how it's been interpreted as it related to, say, police officers. We now have very specific language incorporating things like the mental hygiene law for our OMH peace officers.
And just one more question: is the PowerPoint going to be provided to us? Do we have that to us?
Kristen?
Hello. Oh, God, that's loud. I have one question for Isaac and one for you, Bryce. Isaac, in a video, how can we tell who is who? So I'm assuming the officers don't wear what you're wearing today.
That's a good question. So officers will wear a similar uniform. Unless the chief is getting out of his office and running to the ward, it'll be a dark blue uniform, the same color as my pants, but they should have badges, they should have nameplates visible, some sort of collar device. They should be clearly wearing a dark blue uniform with
Okay.
a patch on the shoulder as well.
Okay, thank you. And then, Bryce, can you, to the best of your ability, explain state versus non-state cases when it talks about the use of force?
What
Does
exactly
this
do you
apply to
mean?
non-state operated OMH facilities?
So all of our safety officers are going to be held to this exact same standard. We have safety officers in every facility that we run. And not every facility that we oversee would have a safety officer, though. But every OMH run facility is going to have safety officers in there. I think the smallest population we have is, I don't know, like Elmira's got maybe 10.
Pretty small.
And then our larger facilities are going to have more. Some of our larger facilities might have 25, 30 peace officers because they're bigger facilities. And all of them are going to be held to the same standard.
Would we expect, I guess, to see a safety officer in like a hospital setting, like a Albany Med, for instance?
Oh,
So, depending on the patient, for example, at Rochester, we have both civil and forensic patients. And the forensic patients are typically going to be escorted by a safety officer whenever they leave the building. So, for example, if a patient becomes ill, maybe they need to go to the general hospital, they will have a safety officer escort. So in that case, yes, they would be outside of the building. Generally speaking, because the parameters of trust don't really work out there, officers are going to be expected to use use of force at that point to maintain custody or prevent escape.
yeah. And one of the chief confusions that we often see is people confusing SHTAs, who are also represented by NYSCOBA, but are not peace officers. SHTAs are front-facing. They're supposed to be interacting with the patient population. They're similar to like an MHTA at our normal psychiatric centers. They just happen to be represented by NYSCOBA, but they are not peace officers. Sometimes they will try to pretend that they are peace officers. They are not peace officers, even though they are NYSCOBA represented.
Does the OMH use of force policy apply to hospital settings that are licensed by OMH, like Four Winds or Albany Medical Center Psychiatric?
Probably not.
That I don't know off the top of my head. I apologize.
Probably isn't.
No, so we were talking about University of Rochester, which is where typically, and I've interacted with that agency, they're going to have their own policy. Obviously, nothing can fall below the constitutional or legal levels, but they're going to have a policy, and the Division of Criminal Justice Services has provided a model policy that they encourage other officers or other departments to look at.
Thank you. The risk of injury and death to
The risk of injury and death to folks that you're putting your hands on is there, as we know. And with PMCS, there's recommendations for keeping an eye on airway, of letting go at the first sign of distress, of starting CPR and knowing and being trained in CPR, debriefing in a way that the nurses now know to watch for a head injury or a fractured arm. Could you speak to any way that you're able to respond to an emergency or transfer that care in an emergency?
Absolutely. So if I understand your statement correctly, in the academy, and actually it's interesting because they're doing that today back in Utica right now, there is a whole subsection of the defensive tactics module that is all post-apprehension in terms of monitoring breathing, checking vital signs and stuff like that, making sure they're not being placed face down, they shouldn't be hogtied, all that kind of stuff. When a safety officer is responding to a unit and it's risen to the level where an officer is now using use of force instead of trust or PMCS, they're instructed that as soon as the environment safely allows you to go back to trust or PMCS, the officers are supposed to be immediately disengaging and turning it back over to the direct care staff. Did that answer your question, kind of, hopefully?
Is there any post-event debriefing where you can let someone know that there could be an injury? That guy's going to have a knot in his head. He's going to have a bruise on his arm, anything like that?
Specifically from like a safety officer to the direct care staff. So I can speak about Rochester. At Rochester, there was supposed to be a we call them Camelots, the psychiatric emergency. There is a form that the safety department fills out and provides to the direct care staff. I cannot tell you if all the facilities do that.
Hi, are safety officers permitted to use handcuffs and pepper spray or pepper gel?
So officers are issued handcuffs and they're authorized and trained to use that. As of right now, they are not issued pepper spray because of the requirements of the Division of Criminal Justice Services. They receive the training to do such, but they're not authorized to carry. So there shouldn't be any times where you're receiving reports that OMH safety officers are utilizing pepper spray. That doesn't mean that outside agencies don't respond. We've had Rochester Police Department use pepper spray on patients and gets cross-contaminated to everyone in the area, but no, safety officers at this time don't carry pepper spray of any sort.
So what would the circumstances be where somebody would be able to use handcuffs then?
Whenever you are detaining or making an arrest. So if I respond and let's say I was going to do a transport, someone needs to be brought outside the hospital and they are a forensic patient, they're going to probably be in shackles actually. If there's an act of assault and I respond to the unit and one patient is actively throwing punches to staff and other patients, officers are going to use defensive tactics and then they're going to end up probably applying those handcuffs unless the level of agitation lowers to the point where direct care staff can get involved and prevent that. So it kind of depends how much staff are involved. Does the officer think that at this point is it reasonable that the patient can be controlled under trust standards? On the units, it's pretty rare to see handcuffs. A lot of times that is more outside of the facility. They're trying to escape. The officer doesn't have any nurses or direct care staff to assist them at that point.
One more question.
You mentioned earlier, kind of touched on the point of restriction of breathing, chokeholds, obviously not allowed, really. In terms of trying to assess, because as you mentioned before, in an incident, it's a scrum, any number of things can happen. You could try and stay composed as possible. How do you assess kind of what I'll call non-conventional, not necessarily being a chokehold, but any sort of, you get arms around a body, or sometimes, I don't know, you're trying to grab an arm, but somehow like the arm and the head kind of get stuck together, stuff like that. How do you assess what you may describe as a technique that's not allowed or just something that led to a restriction of breathing that can be substantiated?
So if I understand what you're asking, right now, safety officers, the current techniques are avoiding any sort of pressure onto the chest, the diaphragm, or the upper back. We are trying to control our subjects on the ground by controlling their hips. There were techniques that were removed within the last 5 to 10 years that were too close to the neck for New York State to be comfortable, and those were removed. And when that change happened, we did explicitly tell departments, look, this technique is no longer authorized. It's too close to a choke. Additionally, on top of that, once a situation's under control, even if they're handcuffed, they're supposed to be evaluating for chest rise and fall, checking a pulse, whatever's within the realm of their training, of their first aid training that they've received for new employee orientation. But they're also explicitly told that you're not medical staff. So if in any sort of use of force, you should be summoning medical staff to your location immediately. Even if they say, I don't want medical attention right now, it's not really their call. They should be summoning the nurse, a physician, an ambulance, calling 911 of some sort. And they are trained to do CPR, and they're also trained that should someone become unresponsive after being handcuffed and even after being placed in the recovery position, that the cuffs need to be removed for CPR because there's a void in the back between the ground and the chest, and that CPR compression becomes inefficient. But does that answer your question, I guess, kind of? Okay. Yeah, it would be tricky. I guess I'd have to see the video. And I've received requests from your agency before to review video, and sometimes it's good, sometimes it's not. They're taught really explicitly that the hips are what control the body. The technique is called knee on top. So I know it sounds bad, but it's actually just controlling your hips. Your hips hold your whole body weight all day, so it doesn't end up causing any damage. But should that knee start rising, what we call north, towards the diaphragm, that's where it becomes that's becoming less and less reasonable. It's more likely to impact breathing.
Well, thank you guys both very much for a very informative presentation.
Thank you.